to the underlying true allele data and underlying DNA data at 5:30 on October 10th. And having spoken with an expert in this case, we would not be prepared to have anyone look at that or be done looking at that and to be able to assist us in our evaluation and challenge of that evidence for at least 6 weeks. Now, that is not our doing. That is not the defense's doing. That is not Mrs. Ross or Ms. Ross's doing. I believe that that is perhaps just a circumstance of this case, but it is necessary for us to be able to proceed with this motion to be able to consult someone who is an expert in this field. The amount of information, number one, is voluminous. And in terms of the ability to sift through that data in the time frame that we have been given, which is, let's call it 2 weeks, 2.5 weeks, is unreasonable. The complexity of that data is beyond the scope of certainly my ability to understand without the assistance of an expert. And as far as I know, the assistance of anyone on the defense team in terms of our training in math, in probability, statistics, as well as computer science that will be what I believe will be presented by the state in this case. There is also a novel aspect of true allele that is pertinent to the court's decision to grant a continuance in this case. As far as I can tell, there are 3 cases in Georgia from the appellate courts that have addressed true allele at all. The only one that does that in any substance is Gates versus the state. That's 308 Georgia 238, a case from 2020. I don't have these cases printed out, and I'm sure that Ms. Ross is abundantly aware of them and familiar with them. Having done a case that took them a year to just prepare for one challenge to this test. But Gates, as well as Smith versus the state, 315 Georgia 287, a 2022 case, involved extraordinary motions for new trial where the defense was introducing true allele, and that was not challenged by the state. The state had not objected to the introduction of the evidence, and the argument in those cases was whether or not that true allele evidence, not the scientific basis for it, but whether or not it constituted new evidence for purposes of the extraordinary motion for new trial statute. The appellate courts in Georgia have not ruled on the admissibility of this science or math or computer program that the state is using to analyze underlying DNA evidence. And the only other case is Nunger versus the state, which is 316 Georgia 1, a 2023 case. And that ruling came down to an issue as to whether or not the defense had preserved an objection about true allele that was decided under the Harper standard. And so I don't think that it is particularly applicable to the admissibility of true allele under Dahlberg. And the fact is that those first 2 cases that I mentioned really highlight the novelty of this science, as the appellate courts have outlined it, which is that they were ruling that it was new evidence. It was a new type of evidence that was not able to even be used by the defense, and such that it allowed them to proceed on an extraordinary motion for new trial. And without the ability to hire an expert and to have an expert evaluate this case, there is no way for us to effectively cross-examine any of the witnesses. In this case, I've looked at it. I have tried to understand what that data is, and I am unable to do so. So, Judge, as to cases that are out there right now, and I believe that Ms. Ross would be familiar with the Deeds case. I think it was Dodge County. That case required a year's worth of preparation with expert witnesses and a week's worth of litigation just about the science of this. And that the amount of time that we have is obviously nowhere close to that. So I would like to just offer a proffer for the court as to the timeline of when the defense began asking for this evidence. In mid-August, the defense mentioned this to Ashley Hinkle, who was the GBI agent who handled the cases. She told us that we needed to go through their open records department. On August 19th, the defense made a request through the open records department to get the underlying DNA and true allele data. That request was denied by the GBI because the testing was not completed in the case. So that would have put us in late August for this. The GBI informed us that they expected the testing to be done by September 2nd, 16th. Ms. Ross helped us in trying to get this open records request done. We offered to limit the open records request to 3 or 4 tests that were done in an effort to speed that process up. We were assured that we would get that information around late September, September 23rd. The GBI says that they would see what they could do about expediting that process. And we didn't get anything back until October 10th. I can wait for the introduction of the test, but I don't think that this will be in dispute, and I will offer as a proffer to the court. I think Ms. Ross would be able to comment on it. The tests that were done that were specifically limited in the open records request, all of those tests had been completed by if I could just look here, Judge, June. I believe the latest test that I have here would be a true allele report. They were given item number 56, and that would have been done on June 10th of 2024. And so, Judge, the fact that we were not given this information until 12 hours, 15 hours before we were scheduled for a motion, again, I don't believe is Ms. Ross's fault, but it doesn't allow us to effectively evaluate or confront the evidence that will be presented to the court today. We're making the request for a continuance and would object to going forward based on Sixth Amendment right to counsel, to effective representation of counsel, Fifth Amendment confrontation.
That's my sign to turn on the air conditioner.
Okay. Fifth Amendment right to confrontation, due process considerations, and any corresponding pieces of the Georgia Constitution. This is not made for delay. This is not made for purposes of delay. We would like to be going forward with this, and I can tell the court in my place that we have made every effort to consult with and talk to lawyers who are more familiar with this information than we are. And at each step of the way, they have told us that this cannot be done, that it is not reasonable for this to be done, that we need to hire an expert. And we need to have an expert evaluate this information. And there are reasons for that. There are reasons for that even from a cursory review of someone who is more familiar with this type of information than certainly any of defense counsel is. I would just ask the court, and what I would present to the court is Judge, may I approach?
Yes.
Thornton versus the state, which is 255 Georgia 434. I presented this to the court because I think that it is helpful in deciding the issue as to whether or not there is a right of a defendant to have the assistance in evaluating and understanding evidence, especially evidence that is novel. This is a 1986 case, and it is about dental records. It is about the use of dental impressions and whether or not a defendant has the right to have an expert evaluate dental records. At the time, that was a novel approach to forensic science, and the court said that where a defendant has made a timely request, and pre-trial, I believe, would be a timely request for that expert on a novel type of piece of evidence that is critical to what the state is going to present. They are entitled to an expert. McWilliams versus Dunn is a Supreme Court case, and that is, I don't have the U.S. site, Judge, off the top of my head, but it is 137 Supreme Court 1790. It's a 2017 case. It is decided under ACI, which I recognize has to do specifically with psychiatric evaluations and experts being required under certain circumstances. But I believe that the logic and the reasoning behind that would be the same, which is that it is necessary for effective representation for the defense to be able to understand evidence. And without that understanding, it is impossible for us to be able to say whether or not what is going on is true or not. And due process requires that if the state has access to these experts, that we also have access to these experts. And I don't want this to go any longer than it has to, but this is very real in terms of the ability for us to understand the information. And so we'd ask the court to continue this hearing.
Ms. Ross, do you want to be heard?
Yeah, I will just put a few of the things that the defense counsel said in context. First, number one, as noted in the state's bench brief in support of the admission of Trujillo, which I filed on September 11th of 2024, I think what the lawyers are having a disagreement upon is the definition of the word new. Trujillo is not new. It's been around for over a decade. It's new-ish to Georgia. We've been using it since 2018. That's still many, many years that it's been here. The fact that the Georgia Supreme Court has only mentioned it 3 times in passing, coincidentally enough, in cases in which true allele exonerated people and the state didn't contest the reliability of the evidence, it's just not new. The federal courts have been dealing with true allele and probabilistic genotyping in general for a long time, as laid out in my brief. There's another program that the court will hear about called Star Mix, which also uses probabilistic genotyping. But there are federal cases right on point about true allele and its admissibility and its reliability. I think the court would be, and I have to separate, I guess, the Daubert from trial in my mind, and I don't even know if it's an appropriate separation, but for the Daubert, the court would be within your rights to take judicial notice of true allele, as some of your other colleagues have done. I attached to my motion a court order from Layla Zahn, the Honorable Layla Zahn, where she actually just reviewed a transcript from federal court, which was in the Northern District of Georgia, of a Daubert true allele challenge in 2019, and took judicial notice of true allele. So I don't think true allele is new. They asked for a Daubert in August, is when they filed for a Daubert. And to back it way up, it was very apparent early on, and I can just for the record here. That April 3rd of 2024 is the first true allele report issued by the GBI in this case, but they would not have gotten it until the first round of discovery, which would have been in May of 2024. So it's very obvious this is a true allele case from the first round of discovery. They filed for a hearing in August. And I am sympathetic towards them about the raw data. It was difficult to get for many reasons, but the last true allele report in this case is actually September 10th of 2024. And the GBI can't give people raw data on cases that are not complete. So this case was not complete by GBI protocol until September of 2024. We did diligently work together as quickly as possible through both open records requests, which I can apparently file on an open case, and a subpoena, which they could apparently, they did drop one, and we worked together to try to get them the data as quickly as possible. And they do have the raw data, and I do think they're entitled to look at the raw data. They have it. But as far as, that's why I think for the Daubert itself, and when you file a motion in August, and it's a general motion, just saying we're challenging true allele, it's new. I filed a response, it's not new. You could take judicial notice of it. I would urge you to take judicial notice of it. We don't need a Daubert on it. That's a different matter to me than what they eventually want to do. But I will tell you this, because he brought up the Deeds case. This is nothing like that case where there's 10 picograms of data, or it's just nothing like that. There's nothing like that case. You can't bring up that case to say, oh, this is so complex. There are judges in this state, because we have been doing true allele Harper challenges and now Daubert challenges for years, 6 years in this state. And to this date, there is not one Superior Court judge in this state that has found true allele to be unreliable. So I understand what they're saying. I'm going to leave it to the discretion of the court. I just wanted to put the timeline in context and put in context for the court what the state's position is, which was in writing, and now, which this is not a new science. You could take judicial notice of true allele for the Daubert hearing, but because they asked for the hearing and the hearing is scheduled, I have my witnesses here. I will put up my witnesses to make a record of true allele and what it is and what it does and how it works. And then I'll wait for the court to enter a ruling.
Do you need to be heard any further on the motion?
Judge, the only thing that I will say is this:
Will this be something new?
Well, as it relates to the time frame, I think that it is, because I think that is a very important aspect of this, and the ability to file a specific motion in this case is impossible without understanding what the underlying data is and having someone tell us what it means. I cannot understand this, and I don't think that it is reasonable. I don't think that Ms. Ross could get up and say any other lawyer could learn this in 2 weeks, knowing what she knows. It is impossible for me to do it. I have tried. I have spoken to people who are familiar with this. I can't do it.
All right. For today's purposes, I'm going to offer for you to go forward with your showing on your expert, unless there's some stipulation about that. I'm just offering that. About your Daubert expert. You need to go forward with.
Well, once they file the motion, if judicial notice is not taken, then it is my burden to go forward, which is why I have my witnesses here and I'm prepared. I'm happy to take a break and discuss with defense counsel a stipulation of sorts, but I'm not sure, by his face, I'm not sure we're able.
I'm always happy to talk. I don't know what it could be, but
Well,
I won't say no without hearing.
Let's go forward.
Yes, sir.
How long is this going to take?
This first witness is going to be, I think, a longer witness, so maybe take either a quick break or, and then decide. I think she'll be about an hour. So if you
Okay.
want to, can we
Sure.
just take a quick courtesy break and then do lunch or not do lunch? Or I don't care. I just
I'm
need a
looking
quick
to not do lunch.
Perfect. May we just have a 10-minute break then?
Yes,
Thank
10
you.
minutes. Thank you. we're back on. You may proceed, Ms. Ross.
Your Honor, at this time the state calls Jennifer Bracamontes.
Jennifer Bracamonte.
She's here.
Say again?
I'm right here.
Oh, well, good. Come on up. I thought you were correcting the way I said something last night. She was in here.
Charlotte, can you unlock this? Oh.
Will you raise your right hand, please? Do you swear or affirm the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth? So
I do.
please take a seat. Spell your first and last name, Madam Clerk.
Jennifer Bracamontes, Jennifer, last name Bracamontes.
Where are you employed?
I am employed at a company called Cyber Genetics, which is located in Pittsburgh, Pennsylvania.
What is cybergenetics?
Cyber Genetics is a technology company that develops and uses the TrueAllele casework software that's used to interpret DNA data.
How long have you worked for cybergenetics?
I've worked for Cyber Genetics full-time since 2012, so about 12 years now, and I was an intern for a year before that.
Tell the court a little bit about your education and your background.
I have my Bachelor of Science degree in biology from Duquesne University, which is located in Pittsburgh. I also have my Master of Science degree in forensic science, also from Duquesne University.
Have you, tell us a little bit about your day-to-day duties at cybergenetics?
So at Cyber Genetics, I'm the casework manager, and that just means I'm responsible for overseeing part of our DNA data processes. So with Cyber Genetics, we have two parts. We have a service part where agencies will send us data to run the TrueAllele software on, and then we also have we sell our software to other laboratories like the Georgia Bureau of Investigation Laboratory and others in the United States. So I'm responsible for just part of our internal casework process, analyzing that data, writing reports, and then testifying in court about TrueAllele results.
Have you analyzed TrueAllele data before?
Yes, I've analyzed DNA data using TrueAllele in about 1,000 cases.
Have you testified to your results before in court?
I have.
Approximately how many times?
57 times.
Have you been declared or qualified as an expert in the field of DNA evidence interpretation before?
Yes, I have.
Approximately how many times?
In the 57 times I've testified.
Okay. And can you tell us a little bit about the number of cases that you have worked in the TrueAllele software program?
Sure. I've analyzed about data from 1,000 cases and then probably close to 3,000 different evidence items.
And Your Honor, at this time I'm going to, may I approach the witness?
Yes.
I'm handing you what's been marked for identification as State's Exhibits 32, and then 33 and 34. I'm just going to leave them up here so I don't have to walk back by. Do you recognize 32?
Yes.
What is it?
It's my curriculum vitae.
Your Honor, at this time the State would move to admit State's 32.
No objection, Judge.
32 submitted.
And at this time also the State would tender Ms. Bracamontes as an expert in the field of DNA evidence interpretation.
Any objection?
Judge, I don't have a way of evaluating that. It certainly seems that she's more qualified than I am.
I will take that for what it was announced. I will allow the witness to testify as an expert in DNA evidence interpretation.
I would like, if you could, to explain to the court TrueAllele and how it works and whether it's reliable and reproducible. So to do that, you have prepared 2 PowerPoints for today, and you remember that?
Yes.
Okay, and are they in front of you as State's Exhibits 34 and 33?
Yes, they are.
Could you first start with State's 33? What is it?
It's a PowerPoint that explains the overview of the TrueAllele process, some of the background, how it works, and how the results are presented.
Okay. And the State would move to admit State's 33.
Any objection to 33?
I'm sorry, is that
It's the first one. It's a smaller case. All right.
Judge, I'll leave it to in the discretion of the court. I think that this would just be demonstrative aids in terms of what Ms. Bracamonte's testimony would be. I don't think that we need to admit this into evidence.
She's asking for it to be, I'll admit it. I mean, I'm the only one that's going to be seeing it
Yes.
At this point. So it's not in the trial.
I understand.
And
That's a
sta-
better way for it to be part of the record, in my view.
Yes, sir. And that's why I'm moving to admit it.
And I will. 33. And is it 34 another PowerPoint?
Yes, sir. States 34, what is it?
It's a PowerPoint that goes through TrueAllele's validation.
And did you prepare that PowerPoint in preparation for your testimony today?
Yes.
State would move to admit States Exhibit 34.
Same thing, Judge.
I understand. The objection is noted as far as admitting into evidence. I will consider that and admit 33 and 34.
If we could, Judge, they are admitted for the record. I think an easier way to display them so that the defense counsel, the defendant, and the court can see is just through the overview. There are no case-specific references to any of these PowerPoints, so I would just request to play it that way. It'll just be easier.
No objection, Judge.
That'll be fine.
So let's start then, and may I approach the witness and give her a...
Yes.
If you could paint it to a pointer for the record, we're starting first at States 33 at page 1. It's just a cover sheet.
Yes.
Right. Okay. So let's go in. Tell us what is true allele.
So starting off with some of the basics, starting with DNA biology, the human body has trillions of cells, most of which have a nucleus that has all of our DNA that's wound as chromosomes. And there are specific regions on those chromosomes or locations that are useful for identifying people.
Okay. And go ahead. So does true allele start with traditional DNA analysis?
It starts with the data produced by that traditional DNA analysis.
Okay. Go ahead.
And so those regions that are useful for identification are called short tandem repeats. And all they are segments of our DNA where there's some repeated DNA fragment, some number of times in a row. And the number of times that segment's repeated corresponds to an allele number, which is inherited from our parents. And labs count up that number of repeats and use that number to identify people. Because it's not only 10, it could be there's 10 to 20 different possibilities at any one location for that allele number.
Okay. Go ahead.
And so we get one allele from our mom and one from our dad. And so at every DNA location, there's a pair of alleles. So here in the example, maybe a 10-12. And that would be what's called the genotype at one DNA location. And so it's not only 10 and 12 in every person. These regions are variable, so somebody could be 13-14, somebody could be 15-16. There's about 10 to 20 different allele possibilities, which results in about 100 possible pairings of those alleles. And then that's just at one location. So testing the 20 or so different locations makes a person's overall genotype relatively unique.
And how does true allele use the data from a genotype? So tell us about it.
So with simple DNA, like DNA from one person, the lab takes that sample, they extract the DNA, make many copies, and produce the data that we see in the middle. And when it's from one person, you'd expect to see no more than 2 allele peaks. And so looking at that data, a person or a computer can then say, well, the genotype at this location would be a 10-12, because that's what the data is showing us. There's nothing at 9 or 11 or 13. And so then with simple DNA, you can just compare that with a known reference and calculate a match statistic.
What is a known reference? What are you talking about?
A known reference would be like a swab from a known person, so like a cheek swab or something that we know came from that person.
Okay. And so that's simple DNA. What about a mixture?
So with DNA mixtures, which are just samples that have more than one person's DNA, let's say in this example, maybe there's 2 people, the lab does that same process to produce that evidence data that you see in the middle, but now there's more than 2 peaks, which indicates a mixture. So now it's a little bit trickier to say, all right, which of these alleles pair together for each of the people? So let's say, but the data still guides that interpretation, so 10, 11, and 12 are the possibilities for the alleles at this location, because that's what the data is showing. So let's say we know one person's a 10, 12. Maybe it's a swab from their body, and there's somebody else's DNA there. Well, what's the genotype for that second person? Looking at this data, that second person must have an 11, because that's not explained by the 10 or the 12. So pairing that 11 with 10, 10, 11, with itself, because you can get the same number from both mom and dad, or with 11, 12, that list of allele pairs is then given some probability or just how well they explain the data. And that's the evidence genotype, that list of allele pairs and their probabilities. And then that, in the same way, could be compared with a known person's DNA, and it would just reduce what that match statistic would be in the end.
And does the computer do the analysis in TrueAllele?
Yes.
So tell us about that.
So what TrueAllele is, it's a computer technology that uses all of the DNA data to work out the different contributors that are there. So in this picture, this is what DNA data actually looks like at one location. Along the bottom is just the size of that DNA fragment, which then allows the scientists to know what those allele numbers are on top of each of those peaks. And then along the left, the height of each of those peaks corresponds with the amount of that person's DNA that's there. The taller the peak, the more of that allele that's there. Smaller peaks, there's less DNA. And there's an overall pattern, highs and lows, and variation. And the computer uses all of that information to work to separate out the different genotypes based on the data.
And was this at one point done by people before TrueAllele?
Yes.
Okay, so tell us about the difference and go to the next slide.
So with prior to computers, what people did to simplify the problem, they basically drew a line through the data. And anything above that line they'd consider, anything below was discarded. So, and what's been seen in studies since then, and why people are moving to computers, is you lose a lot of DNA information by using those thresholds. So in this example, the 17 and 18 wouldn't have been considered by doing a manual analysis. And so that information would be lost.
Okay, and tell us how the computer does it, and also let us know what is the role of a human scientist in TrueAllele?
Sure. So with TrueAllele, it's taking all of that underlying data that a person would upload to it. And then based on their expertise, the analyst reviews that data at every single DNA location to get an estimate of the number of contributors that are indicated by the data. And so they input that number of contributors. In this example, let's say there's maybe 2 people's DNA. And then what TrueAllele does is it works to propose different combinations of allele pairs and assess them against the data and say, well, which ones explain the data better than others? So in this example, maybe I asked TrueAllele to solve for 2 people. It may say that one person's allele pair proposed that is a 17-18, indicated by the blue boxes. And maybe a second person is a 15-19, represented by those orange boxes. And then by comparing those colored boxes, that pattern, to that underlying data, TrueAllele looks at it and says, the tops of those boxes match up with the tops of the peaks. This is a good explanation of that data. So those resulting combinations, the 15-19 and the 17-18, would get higher probabilities for each of those respective 2 contributors. And the computer is not just trying out this one possibility. It's trying out, thousands of different possibilities, moving the boxes around, changing the heights, and just comparing it all to the data to say which ones explain the data better than others. And then it's not just trying good ones, it's also trying ones that don't look like the data. And that combination would get lower probability in the end.
And after it tries all the combinations, then what?
The result is a genotype, which is just a list of allele pairs on the bottom with their resulting probabilities. And it does this for each of those 2 contributors at every location tested. And this is at that one location we've just been looking at for that blue contributor, that more minor contributor, which was the 17-18. And TrueAllele is doing this just looking at that evidence data, never seeing a comparison reference at this point. And here, with this simpler problem in this example, that 1718 was given a lot more probability than the other option it tried out.
Okay. And at what point does the reference sample of potential contributors, for lack of a better term, and contributors are just people, right?
Yes.
Okay. So at what point does a reference sample of a person of interest come into play in TrueAllele?
After the evidence genotype, that blue bar, has been inferred.
Okay.
So it's only after TrueAllele seen that evidence data is a reference ever introduced.
And how many times does a human ask TrueAllele to infer genotypes in one sample? How many times is it ran?
It's run at least twice to show that there's reproducible results between samples.
Is that also concordant? Is that a word you use sometimes?
Yes. So just referring to concordance, meaning you get a similar result each time the computer's run.
Okay. And then what does it give some type of match statistic?
Yes.
After the process is run. And you say we just looked at one allele pair here. How many pairs does it look at, the computer?
So it's trying out virtually every possible pairing for those different contributors and then comparing them against the data at each location for both of those contributors.
Okay. All right, go ahead. But how many locations are there? That was my question, sorry.
It depends on the kit that's used. I believe if it's the Global Filer kit, it would be 21 different locations.
Yes. Okay, go ahead.
And so after those evidence genotypes are inferred, you can compare with a person relative to the chance of a coincidence. So if you pick somebody random out of the population, what's the chance they have that allele pair? And so all the match statistic is just comparing the probability that somebody contributed their DNA or an evidence match versus the chance that it's somebody else or just somebody out of the population. When you have a higher probability of a match versus that coincidence, which is the brown bar in this picture, that gives you an inclusionary statistic. And if it's the other way, where the brown bar is higher than that chance of a match, it's an exclusionary statistic. So TrueAllele can compare with anybody.
So TrueAllele can both include or exclude depending on the data?
Yes.
Go ahead.
And then let's say in this example, maybe the person happened to be a 1718. Well, that would give an inclusionary match statistic at this one location of 8 times more probable than a coincidence, because it's just comparing that 93% versus that 12% chance of a coincidence. And then that same process is done across, in this example, it was 15 locations, but it just depends on the DNA testing kit that's used, how many locations it would do this for. Trying out those patterns, comparing them with the data, writing down those evidence genotypes, and comparing against the reference to calculate the match statistic, which is just how far each of those blue bars sticks out. And then by multiplying these numbers together, that comes up with the overall match statistic.
Okay. And is that called a likelihood ratio?
It is.
Can you explain that to us and how it looks in a report?
Sure. So the way the match statistic is written is just a match between the evidence item and the person we're looking at is 11.8 billion times more probable than a coincidence. And all that is doing is just assessing what's the chance that they contributed their DNA versus the chance that it was somebody else. So it's just comparing that ratio of those two probabilities. When that top number is higher or larger than that smaller number, you get an inclusionary statistic. And if it were smaller in the numerator than that denominator, you get an exclusionary statistic.
And how broad of a range can the inclusionary statistics go?
It could range basically, so if 1 would be your middle point, which is no information because they'd be equal, it would go from there all the way out to, it could be 30 zeros after the 1. It could be larger than that, depending on that reference profile and how rare it is in the population.
And what about the likelihood ratio statistic? If it's higher, does it also mean that the person may have contributed more of their DNA?
Yes. As seen in some of the studies, which we'll talk about, the amount of DNA a person contributed, it can be predicted based, the match statistic can be predicted based on that, so it correlates with that. More DNA from a person, you expect a bigger number. If there's less DNA, you'd expect a smaller number.
And TrueAllele is only used to interpret mixtures, is that right?
It can be used, it's primarily used for mixtures, but you could put a single source sample in and it'll just say, yes, these are the same, essentially.
All right. So tell us how the likelihood ratio relates to the log.
So when you have the likelihood ratio, that number, that bigger number, a different way to represent it would just be the logarithm or the number of zeros that follow the 1. So when you have a number, of 11.8 billion or so, it would be a 1 followed by 10 zeros. And so it's easier to visualize in some of the studies, which we'll see in the logarithm form, or the number of zeros after the 1, versus looking at, billions, trillions, millions, or so.
And is the likelihood ratio just some kind of hypothetical construct, or does it actually mean that person's DNA is present in the sample?
It relates to, it measures the chance that they contributed their DNA versus the chance that it was somebody else. So it's just weighing those two different possibilities.
Okay. But does it mean their DNA is present?
It means that there's statistical, association between the evidence and that person.
Go ahead. And then is there an error rate associated with true allele?
Yes. So there's both an overall and a match statistic specific error rate. And with true allele, we can basically calculate all trillion possible people. And in this image, the bottom just shows that logarithm form, or the number of zeros after the 1, with 0 being no information, 10 being, 10 billion, and minus 10 being 1 divided by 10 billion. And when we compare virtually everybody that could exist DNA to this specific sample, they're largely excluded. And there's a very small chance of a false inclusion. There's nothing to the right of 0 there. And then when we can calculate an error rate based on that for any match statistic as well.
And okay, and is the what is the math based on in the computer for true allele?
The math, it's a statistical model, so it's based on Bayesian probability modeling and Markov chain Monte Carlo statistical sampling. So just
what were the words I didn't hear?
Can you speak a little into the microphone, because it is kind of, your voice travels a little bit, so it's hard to hear you.
Sure. Is that better?
Yes.
Okay. It uses, it's a statistical model that uses Bayesian probability modeling and Markov chain Monte Carlo statistical sampling to work out those different probabilities and proposing and assessing those different possibilities.
And are either one of those two statistical modeling things that you just mentioned particularly new?
No.
Tell us why.
The Bayesian modeling has been around since the 1700s, and then as a mathematical concept. And then the Markov chain Monte Carlo has been used since about the 1950s with the Enigma, or I guess during World War II in the Enigma project.
Now, how long has true allele been around?
True allele was first developed in 1999, and then went through about 10 years of innovation and testing, and then was first used in casework in 2009.
Okay. And before being used in casework, do you mean like forensic casework, like what courts and such like that?
Yes, the first true allele case was in March of 2009.
And we're going to get to it in the next PowerPoint, but before I dig into States Exhibit 34, has true allele been validated?
Yes, it has.
And what is validation?
Validation is just testing any method on data. So putting data in and reviewing the results, and it's used to see that the system's working as it's proposed to and establish any error rates.
And since true allele has been used in forensic work, casework since 2009, how many true allele reports total from not only your lab but across the country do you think have been produced?
Oh, in the thousands or tens of thousands.
How many laboratories are using true allele?
There are currently 10 crime laboratories that use true allele in their everyday casework process.
Has true allele been used in non-forensic settings as well?
Yes, it has.
Tell us about that.
So true allele has been used to identify victims of mass disaster. It was used in 2006 to reanalyze victim remains from the World Trade Center project and compare with family members or personal effects. and has also been used. It was in a 2009, I think, a bus crash in South Africa as well. And TrueAllele's, also been used to help create some of the DNA standards over time that labs use to test that their machines, like to produce the data, are working as expected.
Has TrueAllele also been used in exonerations?
Yes, it has.
In exonerations in criminal cases specifically?
Yes.
Okay. I want to move to State's Exhibit 34, and it looks like you've talked a little bit about the first slide, which is number 2 for the record on the top right corner, but this is explaining DNA mixtures. Can you tell us a little bit about that?
Sure. So the first paper that talks about the TrueAllele results, how it does the statistical model, was published in the Journal of Forensic Sciences in 2001 in a paper called Linear Mixture Analysis, a Mathematical Approach to Resolving Mixed DNA Samples. And this paper focused on looking at p-kite data and showing that it was that sum of genotypes. So when you compare those colored boxes, how that relates to the data. So the underlying basically model behind it was first published in 2001.
And is that a peer-reviewed journal?
It is.
And what does peer review mean in your world? And what is the significance of a peer-reviewed journal?
Sure. So peer review is a process in science where scientists will write up whatever study they're doing, their test of their system on data. They submit it to a journal, which is just a collection of scientific works. And that journal editor will then send it to at least 2 independent anonymous reviewers in the similar scientific field who will then assess the work for its merit and deem if it's suitable for publication or not. And then they'll recommend either the journal publish it, request some edits, or not publish it.
And how many peer-reviewed journals has TrueAllele been in?
Well, there's at least 8 peer-reviewed validation studies, and then there are some other articles like about the methods that have been published in some other journals as well.
The next slide about that publication.
This is just again showing what we already saw, that the computer uses all of the data and the variation.
Okay. And I want to go ahead and do slide 5.
Mm-hmm. So with TrueAllele, there have been over 40 validation studies done. 8 of those have been published in peer-reviewed journals. The system's objective, meaning it only gets that information from the evidence data, doesn't know, can't be influenced by human bias at all during its inference process. It's been reported in 46 states and used by 10 laboratories. And then all of the math, the software, invitations to test the system are disclosed in a large Dropbox. And then TrueAllele can statistically include or exclude people. It's neutral. It doesn't, try to just find somebody or implicate them in the DNA.
And are these all the peer review validation studies that you have already spoken about?
Yes. And the top 5 in the lighter blue are done on laboratory-generated data, meaning data that the scientists knew what they put in to establish, the error rates and see how it works when we know what's supposed to be there. And then the bottom 3 are done on casework data to kind of assess how does TrueAllele work on that data in the wild.
And the next slide is that Dr. Perlin. Who is Dr. Perlin, by the way?
Dr. Perlin is the chief scientist and chief executive officer at Cybergenetics. He was the one that invented the TrueAllele software.
Right, go ahead.
And so the first published TrueAllele validation study was published in 2009 in a journal called PLOS 1, and it was titled An Information Gap in DNA Evidence Interpretation. And this was the very first study that was done on TrueAllele. And kind of one of the main points that TrueAllele showed is that the match statistic is predictable. So along the bottom of this image is just the amount of DNA a person contributed. And then along the left is that match statistic, so what that likelihood ratio is. And what we observed is that the match statistic corresponds with the amount of DNA. When you have more DNA from a person farther to the right, you get bigger numbers. And when there's less DNA on the left, you expect smaller numbers, until the point where it basically gets that single source inference. So it says, this is basically, it kind of maxes out at one point.
That was the first one. What about in 2014?
So in 2014, this would be, I think it's the fourth one in the series, but this is the first one that assesses how you can validate systems like TrueAllele, and introduces the axes of sensitivity, specificity, and reproducibility. And it was published in conjunction with the Virginia Department of Forensic Sciences Laboratory, and it's just titled, TrueAllele Casework on Virginia DNA Mixture Evidence, Computer and Manual Interpretation in 72 Reported Cases.
And I'm going to ask you about sensitivity and specificity and reproducibility separately, but is there another, are there other probabilistic genotyping softwares out there that compete with TrueAllele or do the similar things that TrueAllele do?
Yes, there's about 10 other softwares that would be considered, they're called probabilistic genotyping. So they just use, the math and the probability modeling to look at DNA data.
And is StarMix one of those probabilistic genotyping softwares?
Yes, it is. And that's capital S, capital T, capital R, lowercase MIX.
Thank you. Let's talk about sensitivity. What does that mean, and how does that relate to knowing whether or not TrueAllele is reliable and does what you say it does?
So sensitivity just assesses, the extent to which the method, identifies the correct person. Are we finding those true inclusionary statistics? And in this study in 2014, we looked at 101 reported evidence genotypes and just said, okay, what are those inclusionary match statistics? And what do they look like from TrueAllele?
And what were your results? I'll go back there. Sorry.
Looking at TrueAllele, on the horizontal axis is just the match statistic and the number of zeros after the 1. And what we saw is that there was a wide range of TrueAllele results ranging from lower match statistics, maybe in the thousands, out to over 20 zeros after the 1. The average was about a 1 followed by 11 zeros, or 113 billion. And in this case, we had mixture weights, or the amount of DNA people contributed, ranging from, lower amounts, like say 10% to over 90%. And so just based on, the predictability, we'd expect a wide range of statistics.
And did you do a comparison with human review of the same data?
Yes. And so the original studies more focused on how do computers improve over human review. And in this study, there were 2 different methods done, one with 1 threshold, or the CPI method, where you see there's a smaller cluster of those match statistics with an average around 6 million. And then there was a 2 threshold method, or modified CPI, and a lot more information was lost with match statistics, in the hundreds. And with TrueAllele, there were those 101 inclusionary match statistics. With CPI, there were about 80, and with the modified CPI, there were only about 50. So using thresholds limited the results that could be reported from that same DNA data.
What about slide 12?
And so we also examined TrueAllele's accuracy in this study. And so when you have a wide range of mixture weights, you'd expect a wide range of match statistics. So that's what the black line in this picture is, what we'd kind of expect.
What is a mixture weight, real quick?
A mixture weight is just the proportion of DNA somebody contributed. So if you have a mixture of 2 people's DNA, maybe one person contributed 60%, one person contributed 40%, the numbers will always add up to 100%.
Okay, go ahead.
And so comparing TrueAllele's match statistics with what we'd expect, it roughly follows that line and isn't statistically different. But when looking at those human review methods, they differed from, having a wide range that you'd expect when you have a wide distribution of match statistics.
What is specificity?
So specificity allows us to assess the false positive rate. So are we properly excluding people who didn't contribute their DNA? If they're actually non-contributors, are they excluded?
How did you test TrueAllele's specificity?
So in this study, there were the 101 evidence genotypes, and we compared with 10,000 randomly generated profiles from the 3 different ethnic populations tested. So there were over 1 million comparisons, and then those were plotted here. Along the bottom is just the match statistics and number of zeros. Where you have 0, that's no information. to the right of 0 would be inclusionary, and to the left would be exclusionary. And in this case, most of those statistics where those colored bars are largely exclusionary, with that average information, exclusionary information for those non-contributors, a 1 divided by a 1 followed by 19 zeros. So very, very small, exclusionary statistics. And then we also looked at what's happening past 0, those small inclusionary statistics.
And is that a false positive?
Yes.
Tell us about that, but sorry.
So in the study with TrueAllele, in the over 1 million comparisons per group, we just looked at anything that was slightly inclusionary for those random people we generated. And so with log LRs just greater than 0, so anything slightly inclusionary from, 2 to, in this case it was out to 1,000, how many false positives were in each group? So there are about between 40 and 50 total across the 3 groups, about 150 total. And then most of those were between 2 and 10. They were less than, a likelihood ratio of 10. So very small inclusionary statistics. And so from that, we were able to calculate the false positive rate overall, which is 1 in 20,000 or 0.005%. And then for match statistics greater than 100, that rate went down to 1 in 1 million because there were very few false positives seen greater than 100 and none seen greater than 10,000.
And how does that compare to humans?
So in this paper, there were actually, when the lab did their human analysis, they had some false positives that would have been reported in their reports. So with the 1 threshold method, that error rate was about 6%. With 2 thresholds, that modified CPI, that was about 2% for the false positive rate. And with TrueAllele, it was 1 in 1 million or 0.0001% for those match statistics greater than 100.
Reproducibility is the last prong of the 3 that we were discussing. And so what about reproducibility?
So with TrueAllele, because it uses a statistical sampling method, you're not going to get the same exact number every time because it's going to propose and assess maybe possibly different combinations of those colored boxes. And so, but you'd expect similar results if it arrives at those similar genotype probabilities, those blue bars. And so with TrueAllele, we were able, between computer runs, to assess, what's that variation, what's that difference between those 2 runs.
Sorry. Hold on. Grab this. All right. Okay. And this is when we talk about the 2 runs and the data has to be concordant, right? What is concordant data? And if it's not concordant, what do you do?
So what concordance means is it's just, when you run it one time on that same data, what's your match statistic, which is along the bottom. And then along the left, we plotted what was the match statistic from that second run. So every point, has the likelihood rate or the log LR from one run compared to that second run. And you can see if they were exactly equal, there'd be a 45-degree line they'd all line up on. Well, these roughly follow that, but there's a little bit of variation between them. And so we measured that variation, and it was less than a factor of 10. In this study, it was about a factor of just 2 different between the 2 different runs. And, when they're reproducible, you expect them to be similar every time. And if it wasn't reproducible, you see a number maybe way up in that top left corner.
This is yet another validation study?
Yes. So this was published in the Journal of Forensic Sciences in 2011, validating TrueAllele DNA mixture interpretation. And this study was mainly focused on comparing TrueAllele with human review. So it looked at 8 different case samples and then compared the match statistics on the left between 2 TrueAllele runs, so was TrueAllele reproducible, and then compared it with that human review, that threshold method of CPI. And TrueAllele got about 1 million times more information than human review. And this paper also has a lot of the published mathematics and equations and behind the TrueAllele technology.
And that was in 2011?
Yes.
Slide 20, a 2013 validation?
Yes. So this was published in the Journal of Forensic Sciences in 2013, New York State TrueAllele casework validation study. And in this study, we looked at about 80 different case example or 80 different evidence samples, and then ran true allele on them, calculated those true allele results, which is that blue cloud picture, and then compared with the human review, which is those different colored bars. There were 3 different methods used with that match statistic along the left. And and what we saw is in about 70% of the time, human review didn't get an answer where true allele did. And that just kind of expanded on that first paper we talked about from 2011.
And 2015?
Yes, so the next study was published in the Journal of Forensic Sciences in 2015, titled True Allele Genotype Identification on DNA Mixtures Containing Up to 5 Unknown Contributors. And again, this study also looked at sensitivity, specificity, and reproducibility. But we also looked at how does true allele behave when you have, different contributor numbers, different amounts of DNA. So in this study, there were 2, 3, 4, and 5 contributor mixtures of high template, meaning a lot of starting DNA, and low template, meaning less starting DNA. And so we plotted again that amount of DNA from a contributor on our horizontal axis versus that match statistic, the log LR. And for each group, contributor number and low template, contributor number, high template, and then drew the line saying, okay, well, do they follow that trend where you have less DNA, lower statistics, more DNA, higher statistics? And when we compared those lines together, they weren't statistically different, meaning true allele behaves the same regardless of if there's a lot of DNA or a little bit of DNA, or it's independent of the contributor number as well.
And what is the max of contributor numbers that is used for true allele deconvolution?
True allele has been validated out to 10 unknown contributors.
This slide 22.
So also from that 2015 Journal of Forensic Sciences study, we also looked at low template DNA and examined the sensitivity. So 2, 3, 4, 5 contributors. You can see with 2 contributors, you generally get more information, higher numbers, and then that trend goes, you can maybe get less information with 5 contributors, but you can still get information. And we were also able from this to measure false exclusion rates as well, or false negative rates.
And the specificity 23?
Similar to what we saw before, you're not seeing a lot past 0 on these plots, and it was measured for 2, 3, 4, and 5 contributors for those low template samples.
And what is the definition of a low template sample?
In the study, it was just 200 picograms, and is generally anything 200 picograms or below.
24?
And then we also measured the reproducibility, again, showing that for 2, 3, 4, or 5 contributors, the results, including exclusionary results, are reproducible as well.
What do you mean by reproducible?
That each time you run true allele on that same data, you're getting a similar number each time.
And how does that relate to validation and reliability and accuracy of the program?
It's just showing that, we're not just running it once and saying this is the answer. We're showing that true alleles, looking at that same data and basically generating a similar result every time.
And finally, 2019.
Yes. So this paper was first appeared in the Journal of Forensic Sciences in 2019 and was officially published in 2020, titled Validating True Allele Interpretation of DNA Mixtures Containing Up to 10 Unknown Contributors. And this study showed many different things. Again, showed the the correlation between amount of DNA from a contributor to, the match statistic. And then we also looked at some other aspects of independent analysis. So does who's running the software and where they're running it, does it matter? And so Cybergenetics ran the same data in Pittsburgh, and then this was done with the Cleveland local laboratory. They ran it in their lab in Cleveland. And so the table on the left just shows we got similar results. Didn't matter who ran it or what computer they ran it on. And that was a less than factor of 10 difference between the match statistics. And then we also looked at, peeling, or when you can subtract out a person's genetic type and how that affected the data.
And I said finally, but I didn't mean it. The last one, finally, 26. So
slide 26 just shows that We have a more updated way of calculating true allele error rates, published in Helion in 2018. So efficient construction of match strength distributions for uncertain multilocus genotypes. And all it does is how to calculate those error rates by calculating virtually every possible person that could exist, comparing it with the data, and then saying what are those, specificity and sensitivity distributions. And these results were confirmed by comparing with that sampling method, or those 10,000 random people.
And I'm going to skip 27 because that's pretty much in my brief that I've already covered with the court, which I filed in September. So 28, could you give us a summary of true allele today? Like, where is true allele today? First of all, is true allele new?
No.
Okay. Now give us a summary.
So true allele, the math and everything has been around for 30 years now at this point. The computer system was developed about 25 years ago. There's currently 10 laboratories using it. There's over 530 agencies now across the United States and other countries that have sent data to cybergenetics and had us, examine that data and produce those reports. It's been tested in over 40 studies. Many different talks have been given about it. And then there's, the 42, times in the United States where true allele was admitted after challenge, and those were both in 15 states and federal courts. Cybergenetics alone has done 145 trials in about 20 or to 25 of the states, and that doesn't count all, the user labs or the number of times that here in Georgia, in Ohio, in California, and the other labs that are using true allele, how many times they've gone to court on it. And just from, cybergenetics we've done now, it's over 1,300 cases in 46 different states for both prosecution, defense, innocence, and police groups.
And has cybergenetics or true allele also been used abroad, internationally?
Yes, it has.
And you told us about South Africa. What other countries?
It's been used in courts in the United Kingdom, both in Oxford Court and Northern Ireland, in Australia courts, in Israel courts.
And finally, your last slide.
This is just a summary from that 2014 validation study that true allele is, reliable, it's objective, sensitive, specific, reproducible, and accurate, and more effective than human review.
And if a person does true allele, since it's a computer program, have a source code?
Yes.
And will cybergenetics permit someone to examine the source code?
Yes.
Tell us about the process.
So what source code is it's just the human readable language given to any computer program, any technology that gives the instructions for that software. And so that is then turned into the executable program or application on your phone, or even your phone at this point. And at Cybergenetics, we now have a policy where we will allow opposition experts or any kind of other expert to contact us to come in, sign non-disclosure agreements, and then review that true allele source code. I believe it's currently at our office in Pittsburgh. And that's been the policy, and it's been on our website since, I believe, last year sometime, and is also included in our disclosure materials.
And before I get to the disclosure materials, or maybe I should just do the disclosure materials now, because I want to ask you about something on the disclosure materials. I'm going to hand you what's been, may I purchase witness?
Yes.
What's been marked as State's Exhibit 35. For the record, did you look at State's Exhibit 35?
I did, yes.
And what's on State's 35?
It's the entirety of the true allele disclosure materials that were put together by myself and others at Cybergenetics, and then the GBI downloads to disclose in their cases.
And what types of material does the disclosure material contain?
So there are 4 different folders. The first is reliability, which has, background readings, validation studies, admissibility rulings, and anything you would need for an admissibility challenge. Then validation materials and data, tutorials on how to use the software, and then a folder that contains a read-only version of the software where anybody could review the results, and then there's also an invitation for others to come and test the system on their own. We'd set them up their own little true allele server, and they can test whatever they want, and also that source code information.
And the state would move to admit State's 35 for the purposes of this hearing only.
You heard?
No objection, Judge.
35 submitted.
And if a person wanted to run a TrueAllele on their own for themselves, would you permit them to do that?
Yes, if they'd reach out to Cybergenetics, we would set them up their own, TrueAllele server on the cloud, give them the license to access the software, and then permit them to run whatever they wanted. Data in this case, other validation data.
Is TrueAllele reliable and reproducible?
Yes.
And is it widely and generally accepted in your scientific community?
Yes, it is.
And is it subject to standards and controls and protocols and procedures?
Yes. So there are certain standards and guidelines issued by some of the government agencies that deal with DNA methods, and therefore validating systems like TrueAllele. TrueAllele complies with that, and that information is included in the disclosure materials as well.
That's all I have. Thank you. I'll pass the witness.
Curley?
Judge, I think that this relates to the motion to continue. I cannot confront this witness in a meaningful way without an ability to understand what she's saying. And if I heard it correctly, one of these math theories was used on the Enigma project, and I don't know if that was to create it or to break it, but either way, my understanding of that was that it was pretty complicated. And so I don't have any questions for this witness.
Okay. Can she be excused?
Yes, sir.
Okay. Can we go down?
Thank you.
Yes. Say cause Ashley Hinkle.
Say the last name again.
Hinkle.
Hinkle.
Ashley Hinkle.
And Judge, I think we do have a stipulation with this witness that might make the process go a little faster.
All right.
Raise your right hand, please, ma'am. Sorry, if you stand, sorry. Do you swear or affirm the testimony you will give today in the matter of the state of Georgia versus Jose Alvaro will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Please take a seat. Spell your first and last name for Madam Court Reporter, please.
Ashley Hinkle, ASHLEY HINKLE.
Where do you work?
I work at the Georgia Bureau of Investigation in the Forensic Biology section at the headquarters in Decatur, Georgia.
How long have you worked there?
Approximately 18 and a half years.
What do you do?
I am a forensic biologist trained in serology and DNA testing.
Tell the court a little bit about your education and your training, which qualifies you for your job.
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I also have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center in Largo, Florida. I also participate in continuing education, and I am trained in a software program for complex mixtures called TrueAllele.
Are you classified as a master scientist at the GBI?
Yes, I am.
And how did you get that classification?
I received that classification by staying around for 18 years approximately.
In your 18 years at the GBI, have you had the opportunity to examine items of evidence for blood, semen, and saliva?
Yes, I have.
Have you had the opportunity to process items of evidence for DNA?
Yes, I have.
And have you had the opportunity to run the TrueAllele program?
Yes, I have.
Okay. I'm going to ask you for each of those things, approximately how many times have you run the TrueAllele program? Let's go backwards.
Run the TrueAllele in the mid-hundreds, 400, 500.
And test items of evidence for DNA?
Testified for DNA?
No, test items.
Test items,
sorry.
that'd be in the tens of thousands.
And test items for the presence of biological fluids.
I do that less often, so it's hard to say, but at the beginning of my career, I did quite a bit, so in the hundreds.
Could you please tell the court a little bit about your specific training on True Allele? When did you first get trained on True Allele, and tell us how long that process took and what your training entailed?
The True Allele training began in 2017. Since we are implementing True Allele at GBI, the training kind of ran concurrently to also writing the policies and procedures, so we assisted in that. As part of the training, we did quite a few readings on probabilistic genotyping and True Allele software. We had a visit and presentation from Dr. Mark Perlin, who is the head of the cybergenetics, which developed the True Allele. We also had practice on tests on mixtures were provided to make sure we obtained a correct answer.
And do you receive ongoing training for True Allele?
Yes, I do.
And in general, how to interpret DNA samples?
Yes.
Okay. Are you a member of any professional societies?
Yes, the American Association of Forensic Scientists and the Southern Association of Forensic Scientists.
Are you personally certified?
I am certified by the American Board of Criminalistics in the area of molecular biology.
Have you testified before as an expert in a court of law in the fields of forensic biology, forensic DNA analysis, and True Allele?
Yes, I have.
Okay. And in each of those, I'm going to kick out forensic biology. Let's just talk about DNA, forensic DNA. How many times have you been qualified as an expert in court in the field of forensic DNA?
All over, I've testified and been an expert approximately 300 times.
And what about True Allele? How many times have you testified as an expert in True Allele?
Approximately 60 of those were with True Allele.
At this time, Your Honor, the state would tender Ms. Hinkle as an expert in the fields of forensic biology, forensic DNA, and True Allele.
Any objection?
No objection to the admission as an expert.
All right. So be allowed to testify as an expert in forensic biology, forensic DNA, and True Allele.
May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's been marked as State's Exhibits 36 through 45, and since there has been a stipulation about these, this will go a little faster. I'm going to just show you State's 36. Is that your CV?
Yes, it is.
Okay. And 37 through 45, if you could just quickly look at those and tell me, are those all the crime lab reports that you created in this particular case that we're going to talk about?
Mr. Kirby's standing for some reason.
I am. I just wanted to speak very briefly.
Sure.
Sure.
not see false positives, and we only reported above that match number.
Okay, so does that mean there's a threshold at the GBI in which you will not call a case if it's within the error rate?
There is a threshold where we will not call a match, yes.
A match, okay. Thank you for correcting me. Because you do create, or you do report matches on false, or the potential of a false exclusion?
We have a range with our exclusions where there is a calculated average possibility of a false exclusion.
So of all the items of evidence that you tested in this particular case, did you follow your policies and procedures at the GBI in testing the evidence?
Yes, we did. I did.
And I want to say specifically to the true allele results, prior to going to true allele, did you test the items of evidence using traditional STR DNA typing and analysis?
Yes.
And then how was it then that some items went to true allele, and don't tell me the specific items, but some items went to true allele and some did not? How do you make that decision as a scientist?
That decision is based on whether we can separate a mixture into individual contributor DNA profiles and then compare that to reference samples and match using the traditional DNA testing. We have methods where we can attempt to do that based on the percent contribution of DNA from two individuals. We can separate out contributors. We can also make an assumption that someone is present on an intimate item where we would expect their profile to be present. So if we can use those methods, including another method where up to 3-person mixture, we can pull out a major contributor who's more than 75% of the mixture. So if we can use those methods, then we do not need to use true allele.
Do the policies and procedures then tell you if you can't use those methods that you then go to true allele?
Yes.
Did you receive known DNA samples or reference samples, in this case of Laken Riley?
Yes.
Jose Antonio Ibarra?
Yes.
Diego Ibarra?
Yes.
And Argenis Ibarra?
Yes.
Okay, and did you process those items yourself?
Yes, I did.
Okay. And did you follow your lab's policies, procedures, and protocols in processing those items as well?
Yes, I did.
Are you familiar with all of the policies and procedures that the GBI has on the True Allele software program?
Yes, I am.
And are you specifically trained in those and trained in them if they change over time or update over time?
Yes.
And have you all updated your True Allele procedures and policies over the years?
Over the years, because we started out from scratch, we have updated especially the reporting statements as well as what we need to include in our notes.
And every time that you all get a new testing kit like Global Filer or Identifiler, do you also have to then revalidate True Allele at your lab for the new kits?
Well, we only use it on 2 kits, which are Identifiler and Global Filer, and those we have used since the beginning, and we have a validation for each. But there hasn't really been any changes in those kits. But if there is any changes to the True Allele software program, which also has a server connected to it, then that must have a performance check before it's used for casework.
And the performance check is done by the GBI?
Yes.
The items of evidence that you process in this case that are the results contained in your reports that we have already admitted, were those methods that you use generally or widely accepted in your scientific community?
Yes.
Were those methods published in relevant scientific journals?
Those methods have been, yes.
And are they reproducible and reliable, the methods?
Yes.
And in compliance with the GBI's policies and procedures, after you conducted your testing in this case, were your results peer-reviewed?
Yes, they were peer-reviewed by a scientist who is also trained in the methods.
Okay. And that is all I have, Your Honor. I'll pass the witness.
Judge, again, we're back to the expert issue, and especially as it relates to Ms. Hinkle. my understanding is that Ms. Hinkle would be the application of the underlying science to this particular case. So prong 4 of 702. Without an expert to evaluate whether that was done correctly in terms of the data that we've been given that is not even in narrative form, I need an expert. And so until I have an expert, I will either reserve cross or I don't have any questions for Ms. Hinkle.
Thank you. Anything else with this witness?
No, sir, may she be excused.
You may excuse. Thank you. Any other evidence?
Not on the Daubert for Trujillo, no, sir, no evidence.
And I'm going to offer Mr. Kirby, but I don't expect you.
None from the defense.
Do you want a summation on this issue?
No, sir, it's in my brief, and again, I would encourage the court that you could take judicial notice of it even without the need of a hearing for Daubert purposes.
Okay. And I'll offer you if there's anything else you want to say. Here's my plan or my thought on your issue related to a continuance in order to get an expert. I'm going to ask you if you can answer this question and read in what you said earlier and what I saw in your motion. As of right now, you have not identified an expert. Is that correct?
We have identified a potential expert, yes, Jim.
All right. But, which leads to the reason that you're asking for the continuance.
Yes, we contacted an expert. They informed us that that's what they would need, and I would be hopeful that that is a number. In talking to other people, that seems like, I don't know. I'm hopeful. We've been trying since we got this information. So I just want the court to know that, and I want everyone, the state to know that this is not about purposes of delay. We don't want necessarily this to drag on any longer than it has, but we have a duty to our client.
But in reading your motion, you're asking to not only continue this hearing and leave that opportunity open, but you're also asking to continue the trial.
We recognize that the effect would be to continue the trial. And again, I've explained why that is,
That's right.
and we feel like we have to do that.
Well, let me give you some direction on that. It is not my intention at this stage, or based on what I've heard so far, to continue the trial for that purpose. However, I will leave open the opportunity if you want to bring someone in as an expert and we need to have a hearing on that, not for continuance purposes, but perhaps to do some examination or put on your own evidence. I'll leave that opportunity open depending on what it is. I understand what you've said, that you don't think you can accomplish that, but that's where we are today.
Okay, so just to try to get a clarification as to the court's ruling, there is not a denial to the continuance for this purposes of today?
I'm leaving this open for you.
Okay.
But I'm not bringing back anyone else for that. It would be around the trial as a practical matter if you want to reopen some of that outside the presence of the jury.
Okay, thank you, Judge.
Does that make sense?
I think
I'm not
that
trying to be
No.
obtuse about this.
Well, Judge, and I think that from a practical standpoint, it doesn't matter. It's just, we have explained our position in terms of confrontation, Sixth Amendment, corresponding sections of the Georgia code that we were asking, that we're objecting to this and asking for that continuation.
And I'll be putting this in a written order, but I just think as much as I can tell you today, because we're a couple of weeks off, you need to know. And
Yes.
that's why I'm trying to do that.
I appreciate that, Judge.
Sure. All right, where does that leave us then?
Argument on fingerprints, Your Honor.
Okay.
That's, I believe the defense decided not to call their experts, so the evidence is closed. The state would have nothing to rebut, so the evidence is closed.
You handling that, Mr. Donnelly?
Yes, sir. Just briefly, so we under 702, we asked the court for permission to leave the evidence open to possibly present someone. We're electing not to at this time, but the case law tells us that the burden would be on the proponent, but that would be the state, of the proposed expert testimony. I'm citing their National EMS versus Smith, 368 Georgia Appeals, page 18. And this would include the burden to present evidence of reliability, not just evidence of the witness's qualifications. And another citation from a recent case is Humphrey versus Emory Clinic, 369 Georgia Appeals, page 131. And so in 702, I think it's B, has 4 prongs to it. It's not alternatives, but the court must be satisfied that all of them have been met. And we don't have any issue with the first 2. That is the experts training, or that the testimony is based upon sufficient facts or data. But really the second, prongs 3 and 4, 3 being the testimony being the product of reliable principles and methods. And we would point out that the witness acknowledged that, Detective Stewart that is, acknowledged the federal study pointing out a concerning error rate of false positives in fingerprint comparisons. And he acknowledged that was 2016 in this federal study that they refer to as the PCAST study, and that's an acronym, PCAST. And that study called for additional peer-reviewed scientific studies of fingerprint comparison for this to really be forensically sound, scientifically sound. And the state could not cite any, the witness could not cite any peer-reviewed studies that have addressed the problem that was pointed out in 2016. What he did testify to, and the state introduced these into evidence, was that in 2017, in a body, it's a national body, OSAC issued guidelines setting out the ACE-V, another acronym, ACE-V method, and the witness said he followed that this is a widespread method and that it has been accepted. But also, again, there were no scientific studies to prove the reliability of this method, and specifically no testimony as to a known error rate, which obviously that's one of the things that the case law talks about in looking at for prong number 3. And in fact, the state made a point to bring that up in this last with the DNA witness. And then the 4th prong, the court has to be satisfied that the expert reliably applied the principles and methods to the facts in the case. I think this is a little bit bigger of an issue here. The report that the state introduced at the first part of this hearing of Detective Stewart's analysis is basically, the analysis portion of his report basically has 2 very conclusory sentences, and that report is in evidence. There's no detail, no documentation in tandem with the analysis from which another scientist or examiner, I guess, could determine whether the method that this witness used is capable of being reproduced, capable of producing reliable results. Yes, it was done a second time. There was a second analyst who reviewed the fingerprints and came to the same conclusion, but really without any documentation in tandem with the first examiner's analysis. There was nothing for her to follow. She was basically doing it anew. The documentation, there was documentation presented in court to accompany his testimony, but that was not created at the time that he came to his opinion, that he formed his opinion. That was prepared simply for court, as a demonstrative aid.
Are you talking about the peer review?
No, I'm talking about the charts that he brought in with the blow-up of the latent lift and with the known print, and he had color markings on them. Those documents, but other than that, he didn't have any objective documentation of what he did initially to form his opinion, so that another examiner could review that. As far as the court's assessment of this fourth prong of 702, there's also the lack of an APHIS confirmation. The known print was included in the APHIS system, yet APHIS did not find a match or even a close enough, within 20 candidates, within a close example to the unknown latent lift. So, I understand the state's position is that this is a long-standing forensic method of fingerprint analysis that's gone on for years and years, and it's been introduced in courts all the time, and that it would be shocking for this court to exclude it. But there's not a Georgia court that I can find in after 702, that goes into any detail about the admissibility under 702, since this has only been applied to criminal cases since 2022. So I'm sure to the state that this is a stretch, that we are asking the court to exclude that witness's opinion. What I am asking the court to do, if the court finds that the witness is allowed to give his expert opinion, we are asking the court to order that opinion be tailored. And in that regard, I have a case to cite, Hart, H-A-R-T, versus, I guess it's Phone, P-H-U-N-G, 364, Georgia Appeals, page 399, that's from 2022. And that's a civil case with a car accident where there were experts trying to talk about the lighting conditions. And the court in that case held that this one particular expert could not go as far as to describe what the lighting conditions would have been in the situation. But he was allowed to testify to things that could help the jury. That these lights on this vehicle would have provided this illumination. The light on the street would have been, provided this illumination. The distance that the pedestrian was from the vehicle was this. He could have given opinions that would not have otherwise been, known to a layperson, such as the illumination that the vehicle would have provided. But he couldn't go so far as to give a more specific opinion as to what the driver could have seen. And so, in this case, and I understand that it's somewhat different, but what they did in that case, the Court of Appeals on review said, look, we're not finding error with the trial court's admission of that expert to give an expert opinion, but that it should have been more tailored and that it went too far. And so I think that this court will be authorized to do that. And what we think that based on Detective Stewart's testimony, so again, I'm referring to the document that the state introduced as far as his written report, the essentially 3-page report, although the third page there's no content on it. So the second page of that report, where he comes to his conclusion, he says that the latent and the thumbprint of Jose Ibarra have a great deal of corresponding ridge detail. Well, I'm not going to read the whole thing, but there's 2 sentences there that his policy authorizes him to make as far as the similarities between these 2 fingerprints. But the last sentence, when he says the left thumb of Jose Ibarra is the source of the latent on the cell phone, we would object to that, to him being allowed to say that. And that is in keeping with his own policy. He testified, and it's in evidence, the police department's policy, also the OSAC guidelines, which are also in evidence. Neither of those authorizes an examiner to go that far in his opinion, and the science just doesn't authorize a claim that bold to make a statement that this person is the source of this latent print. They can't even see the entirety of the latent print, as we saw in the blow-up. So we would ask that if the court does allow the witness to testify as to an expert opinion, we're asking it to be limited to those first 2 sentences in his conclusion, and to prohibit the witness from testifying to that last, more broad and unsupported statement, if that makes sense.
I understand. Thank you.
Again, Your Honor, the state had filed a response to their Daubert request urging the court to take judicial notice of the reliability of fingerprint evidence. And counsel said there is no Georgia case on point, but the last time I checked, the 11th Circuit Court of Appeals is in Georgia. And the 11th Circuit Court of Appeals held in 2023 that fingerprint evidence is so widely accepted. And I cited to the court an opinion from 1911 where fingerprint evidence was discussed, that fingerprint evidence is so widely accepted in the federal circuits, which is what our Daubert statute models under 702, the Georgia General Assembly tells this court we have to look to the federal circuits. And in looking to the federal circuits and looking at the 11th Circuit, in 2023 they have held it is so widely accepted that you don't even have to have a Daubert hearing on it. You don't. We asked you to take judicial notice of it, but we had a hearing anyway, which is great. We have a great record. And on this record, there is no basis to grant them the relief that they are seeking. And it's interesting that they are now challenging the reliability of fingerprints in general, because when we had our discussion about why we're having a Daubert fingerprint analysis, it was more they were attacking the expert and the way that he did it and not fingerprints in general. But even if they're attacking now fingerprints in general, they had the opportunity to ask the expert if fingerprint evidence is unreliable. I'm assuming he wouldn't agree with them. And he did talk about generally how reliable fingerprint evidence is done. And he talked about the ACE-V method. And the reason why that is so important is because the V is for verification, and his work was verified. But there's also, since 2022, since Daubert was enacted in criminal cases, I do have 2 court orders from other superior court judges in this state who, like Your Honor, have had Daubert hearings and fingerprints, who have talked about specifically the ACE-V method. And you can find the ACE-V method in all the cases that I cited to the court in my brief about it being inherently reliable. And so if I could, one is out of Fulton County and the other one is out of Augusta. There are 2, obviously it's persuasive authority, but I just thought I would share these 2 court orders with the court on fingerprint and ACE-V.
That's fine.
May I approach?
Sure.
So we request that you deny their Daubert on fingerprints, and the request to limit the expert's opinion to something that is really no opinion at all, it's just not logical and supported in fact. He's an expert in fingerprints, not lighting. I could see a civil case that I haven't even read because I didn't know he's going to cite it, where you don't need an expert to talk about the lighting. That's really kind of something the jury can figure out. But he's talking about fingerprints and matching a fingerprint to a known item of evidence. And so we request that you allow him to testify to his full opinion, which was outlined in his report and which was explained to Your Honor a few weeks ago.
Does that cover the subjects that we were here for?
The only other one was the motion to particularize the witness list, and I
mean, I guess you're just, I haven't seen the list, so I don't know. Does the state have a position on
I have
what they may do
told them,
about
I
that?
just haven't done it yet because we've been so busy preparing for motions. I will limit and tell them, I will give them a range of civilians that I'm going to call. I have told them I am hamstrung because I'm not sure what they're going to do, and I'm always able to call anyone on my witness list. That's why I put them on my witness list. But so that the trial will move efficiently and they can be prepared, I will give them a narrowed list, but I'm subject to calling anyone on the list, which is why I list them. And I don't want to box myself in because I don't know what they're going to do. So obviously they could do something that's going to require me to call someone who's on the general witness list but wasn't on the narrowed witness list. So my way of saying I want to be agreeable, I want to help, and I want to narrow it for them, but I can't be bound by what I tell them because I have a burden of proof here. And if they do something that's going to require me to call someone that I've already listed, I reserve my right to do that.
And Judge, I think we put it in our motion. I'm happy to put it on the record here again. We don't object to that position. We're not asking for the state to commit themselves to only calling these witnesses. We're not asking the state to limit their rebuttal possibilities. We're just, in good faith, trying to prepare for this trial. The data is voluminous, and so if we would just have some notice of who the state actually has under subpoena, that would just allow us to be ready on November 13th.
Okay, it sounds like that's done.
Yes, sir.
Yeah, and it would be helpful if the state had gotten any witness list from the defense, and I know we're not 10 days out yet, but once I get a witness list from them, then I can better limit and tell them who I'm going to call.
That sounds reasonable, doesn't it, Ms. Beth?
Thank you.
If we have witnesses to call, we're happy to alert the state, but at this point, I don't know, we don't have any witnesses beyond what the state's predicted.
All right, I'll leave that to you all. Couple of things. One is, I just to kind of give you all an idea of how I want to try to proceed on the 13th. I've talked with the clerk's office. We're going to go ahead and bring in all the jurors Wednesday. Y'all have done a good job in coming up with a juror questionnaire. I mean, I think it's 53 questions.
Yes,
and I think that will tell you all a lot, but of course it's going to take some time. They'll get checked in. They're all going to be given the questionnaire. Then they're going to be loaded. These are just kind of housekeeping things, but I think it's helpful to you. They will put them on iPads, 2 or 3 per side, load them on. If you all want to take your iPad and download printed copies or print out copies, you're going to be able to do that. As soon as we're able to identify, get them in panels and do the first 12, those are the questionnaires I'm looking for first, even though they'll all be doing them. We'll go ahead and start the void eye with them. We're going to do everything in the courtroom across the hall that are known as Judge Stevens' courtroom, from jury to trial. I think it just makes sense now that I've thought about it to do everything there. I also will tell you now it is my intent to have jurors referred to by their summons number.
Yes, sir.
And the questionnaires will, of course, not be available to anyone either. Also, I will, since you all have done such a good job on the questionnaire, I am not looking to spend time in void ire asking those questions. I understand there will be follow-up, but I'm also not looking for what I call rapport establishing questions. They're going to get to know you pretty well during the process of this. Certainly, I'm going to let you introduce yourselves and everybody, but we're going to be able to do that early on. I'm just looking to not spend more time than we need to with them. It's going to be cumbersome enough as it is. The last thought I have is y'all got a notice about plea day on that calendar for the 12th. Unless you all tell me differently, I don't know of a reason to call you all together for the 12th. If that changes, let me know. But I mean, we could make room. But I'm also not saying that to invite a time to hear other motions and all of that necessarily, because I'll have other things to do. But I just am letting y'all know that we need to be here for that.
So we are officially excused from the 12th?
That's correct.
Thank you.
I have one logistic question. We had talked about the possibility of individual voir dire when following up on some of the questionnaire questions, and the reason I asked that because obviously some of the questions will deal with what actually do you know about the case, and I don't want to ask that in front of other jurors to
Sure.
keep them.
Do you want to be heard on that?
What is the court's general policy on that?
Okay. I do sequester voir dire from time to time, especially when there is allegations of sex acts. Sometimes people are not as forthcoming with their issues related to that. So that alone. But I can also see a reason to do it in this case as well, just as I think Ms. Beck just mentioned. So the way I usually work that is, of course, we end up with 12 jurors over there. We put them in the jury room and bring them out one at a time. And if there is some follow-up with each one, then we address that then. Then, as a practical matter, I usually have them step outside and then I entertain any motions related to that particular juror. So we have sort of a running total of who we qualified. I polled the other panels. I try to stage it so that they come in and they're not waiting, but they would have to be waiting probably out here in this atrium. We may have another place for them to wait and gather as well. That's what I'll be looking for. But that's usually what's done.
When you handle sequestered voir dire, do you handle just that sensitive topic, or do you go ahead and complete all the questions for that?
I usually do everything for that juror. I think but in this case, with y'all got all of those questions ahead of time, I just do the sequestered voir dire, anything that we think has to be dealt with on that particular juror, not just what I call sensitive questions.
Yes, Judge, and I would just offer that at least right now, our position is that we don't need to question the jury in groups of 12 if we're doing individual voir dire, because all of our general group questions would be in the questionnaire. So,
With the exception of it did not put the statutory questions in, and so are you going to bring them all in to do the statutory at one time and let them know certain things like, this is not a death penalty case, and we're going to take your phones, and you're not going to be sequestered, all that kind of stuff they want to know?
They live here in this county.
Yes. All that stuff will be.
Those statutory questions I'm going to do as a group, I hope. May have to do it in two sections, but I'll have to ask all of those.
And the one thing that I did not put in the questionnaire is an actual witness list, like I made.
Saw that.
So I need to plug that in. Do I email that to the court, or how do I plug that in? Or do you want me to plug it in and email it back out to everybody?
You can email it to my office, of course, copy all parties, but that'll be fine. I'm hesitating because we're the stipulation about trying to have the list. I don't know how exhaustive a list we're talking about.
So what I could do is, what we've done in other cases, is when you do the statutory questions, either you could read the list at that time to the entire panel, just ask them to raise their numbers, if they have numbers, or I could read the list at the time, or they could read it. We could just figure out how we could read the list at the time instead of writing it out. I've seen it done both ways. Sometimes we print it. Sometimes we just, when they're all together and you're doing your statutory questions, you usually hit the buzzer to the state and you just read out the witness list and say, raise your number if you know these names.
Sure.
And then we can just note it and then follow up on it when we follow up.
I think Your Honor's concern is I would request that rather than reading the 265.
I'm not doing that.
Okay.
It'll be the reduced list.
Yes, sir.
It's not going to be 265
Okay.
people.
Well, let's try that, because they're going to be overwhelmed a little bit by the questionnaire as it is, much less,
So try reading it, not putting it in.
yes.
Yes,
And
sir.
it doesn't matter to me too much whether I do it or you. I tend to say it's your list, so Ms. Ross reads them out.
Your other judges are in your company, yes.
Okay. Anything else we need to talk about?
Two other additional matters briefly. I need to give the court a court order for State's Exhibit 31 from today,
Right.
which was the thumb drive. So I will just submit that via email to all parties. That will give the court the opportunity to in-camera review it and then decide if you're going to sign that order. And then we would like to just make a record to make sure that the translation is going well and there are no issues with translation. We don't see any, we don't hear any. I just want to make sure that the defendant is understanding the proceedings for the record.
Do you want to?
In what form would that be? I don't understand.
Well, I guess I'm looking for, and I think it's a reasonable request while we're here on the record, is there any problem with the translation? I assume the equipment is working and your client is getting the information. If there's a problem, I would like to know it. We all would.
Certainly, we would bring that to the court's attention.
Okay.
I'm not aware of any either. I just don't know what we're looking for there, an affidavit or a.
No.
No,
It's an
I don't
inquiry.
think so.
Oh yeah, I'm not aware of any. So
Okay.
let the court know.
Well, certainly that door is always open if there
Your
is.
Honor, now and then I ask him, are you understanding what I'm saying? And he answered yes with the head. So I did need to make sure that he understands what I'm saying.
Okay. Because we are also dealing with electronic, I guess there are batteries involved. I don't know.
I have them.
Okay, all right.
Everything.
If something starts happening, let us know.
That's it.
All right, thank you all. I will take, the court reporter gets nervous about this, I will take 31 and hold it.
I'm going to sit here and take that over.
Do you also have a little extra chance?
I do. I'm really bad at things.
That was my third one. It's here somewhere. Here it is.
31, I believe, was the number.
31 is definitely the number. I just say your hand since I've got my mask.
I mean, yes. Jamie has it. But I'm the same. Okay.
35 is in height.
I noticed that today. I did.
35. I've got it. It's going to be soon, I expect.
Because what I do is transport it, I just like a few months.
Turned off.
We'll have them